I could work 4 hour church. 4 minutes and 4 hours. Twice.
Sometimes it's physical.
Total 8 minutes for 5 minutes.
Welcome to Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching a miscellaneous criminal felony docket day. Now, on this miscellaneous day, it's going to be split into several parts, and this is a new change for 2023. In the mornings, we're going to have smaller violations of probations, maybe some smaller hearings, things like bond hearings where maybe somebody's stuck in jail. Otherwise, you're going to see people who violated their probation, most of which are going to be in jail because violations of probation are not granted a bond automatically. So you're going to see those kind of hearings where bond hearings, or people who are admitting or denying that they violated their probation. Now that's the morning segment. In the afternoon, and this is the new change, for 2023 we have felony plea day. Now this is, some places call it arraignment. This is going to be the first time that people have gone into court. Now these are going to be people who have not hired a private lawyer at this point. If they've hired private counsel, they're going to waive this arraignment date. However, people who have not hired a private lawyer are going to be there. They're going to be told what they've been charged with, and they're going to get the opportunity to let the judge know if they want to hire private counsel or apply for a public defender. Now, immediately following felony plea day is going to start the afternoon portion of the miscellaneous docket. Those are going to be your longer hearings and sentencings. Hearings like a suppression hearing where someone's trying to prove that maybe the police didn't do something right. These are going to be those hearings where you have witnesses, probably multiple witnesses. And then on the sentencings, you're going to have people who are asking the judge, give me a lighter sentence. The state's offered this. I'm trying to get something different. I don't want the state's offer. I don't want to go to trial. I know I've got a plea, but please give me what I'm asking for. And they're going to bring in those witnesses, like they'll bring the preacher, they'll bring their family members, the coach, someone just come in and say good things about them and maybe some mitigating things about them to justify giving them a lower sentence. So those are going to be mostly what happened in the afternoon. There'll be less of those, obviously, because they take longer, where the morning docket might have 50 people on it. The felony plea docket might have 50 people, and the felony plea docket goes rather quickly. This afternoon miscellaneous is going to have normally less than 10, and they're going to be the longer hearings, more detailed, more witnesses. So that's what you're watching today on miscellaneous criminal felony day.
Please, circuit court is now in session. The Honorable Judge Terrence Mitchell presiding. Please be seated.
Sorry for the delay. I got caught in that accident.
Probably missing a few.
You said one? That's it. Oh, it's a bar. Okay. Oh, nice. Yes, that is. I've done that before with kids. Yeah, I've done that before, obviously.
Mr. Dyer.
Good morning, Your Honor.
Good morning.
I have Mr. Jordan on the docket. He's an inmate.
He is, that's correct. I'm not adopting anybody else, too.
Your Honor, Mr. Georges is present in 24 CF 997. He is before the courts on a motion to reduce bond. Your Honor, his current bond is $205,000. He is not able to post that. He is 37 years old. He works for himself. He's lived in the area for over 22 years, Judge. His mother is 71 years old. She lives here. He helps care for her. He has a wife with a 2-year-old, and they are present here now. Judge, he has strong ties. He has a family to work for. I do not believe he's failed to appear. The state did stipulate to a bond of $21,000. I believe there are 21 counts, pre-trial services, GPS. So, Judge, we would ask the court to grant that and reduce the bond, please.
State.
Okay. Your Honor, due to the serious nature of the charges, we certainly believe that there should be a monetary bond in this case. The primary concern the state has is we want to make sure there's safeguards in place to assure the safety of the community. So we were willing to agree to a lesser monetary bond, but we think it's critical that there does need to be pretrial supervision. He does need to be on a GPS monitor. We're also asking, Your Honor, that he not be allowed to, I believe one of his occupations is to be a realtor, and we ask that he not be allowed to show any houses during the pendency of this case, because there might be some inadvertent contact with juveniles in that, and we are asking for no contact with any juveniles, along with no internet access. He does have a history, Your Honor, of possession of controlled substance, DUIs, and driving without, but we are also not aware of any failures to appear.
Mr. Dyer.
I don't have anything further, Judge. I do not believe he is showing homes. We would have no objections to the no internet access and anything else the court would ask.
Based on the stipulation of the state and the requisite protections for the community with the GPS monitor, the court would grant the reduction as stated with the pretrial services that would include no contact with minors, no unsupervised contact with, even with your own children, unsupervised. You can have contact, but not unsupervised, and be placed on a GPS monitor at $1 a day. No showing of homes with your real estate in order to avoid any inadvertent contact. And please understand, this is an accommodation, this type of a bond. If there is a violation, they'll pull it, and you won't get out until after you have your case resolved. And these cases do take some time, generally. So just understand
I have it proposed.
that. Okay? Have
Thank
you
you. The
reviewed?
state has reviewed that, Your Honor. I believe it includes the additional safeguards that we just discussed this morning.
Very good. Okay. Thank you very much.
Thank you, Judge. Have a good day.
Your Honor, Mr. George, this is my only case. May I be excused?
You may. Thank you.
What's yours?
Let's do a couple of these without an attorney. If you're here without an attorney, you're probably here on the first hearing on a violation of probation. This type of a hearing is akin to an arraignment where you're going to be making a plea. If you do not have an attorney, you do have a right to have an attorney in these cases if you cannot afford one. So I'm going to ask you if you want to have an attorney appointed. Of course, you've got to fill out the forms and all that. But what we'll do is we'll enter a denial on your behalf so you have a chance to meet with your attorney. So just keep that in mind. I'll repeat that when you come up. Is Mr. Wade Fleshman here? State?
Your Honor,
Come
the
on.
state would ask for a KPs.
Has he been served?
I'm checking right now.
You know, given the traffic, I might suggest we pass a
Okay,
little bit.
that's a good idea. I agree with that. Okay, so we'll just pass over that. John Gesford, seeing that I was 15, 20 minutes late, I guess I can give some other people some slack. Gesford? Okay. Patrick Hart?
Your Honor, that case was resolved on 5/16.
Okay,
Yes, Your Honor, this case was resolved last week.
very good, thank you. Justin Manios?
Your Honor, Mr. Manios, I'm not sure how to say it, but Manios is approaching the podium. That's 21 CF 777. Your Honor, this is my case. The state's offer in this case is for the court to, I believe the court should order the remaining financials to a lien. And then after that, the state will withdraw the BOP, Your Honor. This is a financial only violation, and he does currently have a withhold of adjudication.
Okay, so go to a lien on the financials. What about is he going to continue on probation?
Yes, Your Honor, he will continue on probation until his termination date.
If he has financials and he still is on probation, how is he violated? Doesn't he have until the end of probation?
They have to do a 90-day review, Your Honor, so
Okay, I'm not following.
Manos.
Do you understand my question?
Your Honor, I'm sorry, give me just a second, I'll check his termination date.
Okay,
What-
but answer my question though.
Yes, sir.
It's my understanding that if he has time left on his probation, he can't be violated for financial because he has until the end of probation to pay it, doesn't he? I'm just wondering why he's even had a violation file. Maybe I'm just not tracking this.
Your Honor, his termination date is June 13th of 2024, so we are less than 30 days away.
I understand that, but can he violate if he still has time left on his probation, whether it's a week or 6 months? I'm asking a technical question.
So, we are required to do a violation report 90 days prior to.
Okay, 90 days prior.
We take it out
Gotcha.
to 30, and he,
Okay,
Yes.
very good. That's what I wanted to understand, kind of the procedure.
And
Okay.
Your Honor, just from a legal perspective, he does currently have a withhold of adjudication. So this, because it's financial only, the state is attempting to allow him to keep his withhold. Because if we revoke and terminate probation, he's going to be a convicted felon.
Okay, so you've heard a lot of this talk. You still have the right to have an attorney. The offer by the state, if you don't understand it, and you want to talk with your attorney, I can appoint, we can come back next month, you're still, you know, you won't be, you can still resolve this, or you can go ahead and accept the state's offer to basically, did you hear what they said? Yes?
Yes, sir.
Do you want to take the state's offer and just have you go to a lien? I don't want to advise, I can't advise you one way or another. Do you want to talk to an attorney before you do it? Okay. So the court's going to appoint the public defender. I'm going to enter a denial, and we'll come back on, when is he going to violate? When is he going to end?
termination, well, is
When's his termination?
June 13th of 2024, but also for the court's information, he hasn't done his public service work either, so it's more than just financial stuff.
Okay, well, that's just what the state just told me, that it was just financial, so that's all I can go by, I'm sorry.
Your Honor, he will need,
Yes, you may.
He does need to complete a public defender application, even if he hasn't public defender before, okay? It's submitted on the first floor, okay?
We'll come back on June 13th,
That's my card.
9 a.m. Make sure and meet up with your attorney, because you got to get this resolved one way or another, okay?
Yes, sir.
Okay. Mr. Flowers, do you have one? Have a question?
Your Honor, my client is Jerry Hollingsworth, who was set for sentencing today. Have not
Is that
heard
the
from
one this
him.
afternoon?
Well, I thought it was set this morning,
Oh,
but
no. Hold on a second.
yeah,
There was one sentencing, it was this morning that, I didn't think, I thought it was under the PD though.
good. Madam Clerk, perhaps you could educate me as to when it is set.
When is this set?
What's the last name?
Hollingsworth.
It should be set.
I'm sorry.
It should be set for today. So just, it's on the docket.
So it should be on the document, but it's not on the document.
He pled on April 18th.
He did, and it was set for today. Judge,
Okay, go
I'm
ahead.
going to ask that you give him a few minutes. It took me 40 minutes to get here. My office is by the hospital.
I understand.
Yeah, so I will attempt to reach out to him.
Okay, what is the?
Judge, he had entered a
The
plea.
case number, do you know?
No, sir.
Madam Clerk, do you have a case number?
CF 1975.
Last four digits, I'm sorry.
1975.
Okay. Let's just hold on it, Mr. Flower, we'll see if we, sure. Okay. Who wants to, Ms. Farkas, you want to do it? Mr. Rudy's not here?
Mr. Harper may be speaking with clients, Your Honor.
Sure, I mean, I know he's around, but,
I've got one out custody I can handle real quick.
okay, that'd be great.
It's going to be Mr. Gary Ivy.
I think Mr. Ivy is scheduled for arraignment today, Your Honor.
Correct.
At this time, if we can enter in denial in his VOP and continue the case without subpoenas.
Okay, we'll come back on June 18th, 9 a.m.
Yes, sir. Thank you. Your Honor, there's another one that Parker Guria.
Yep.
Mr. Guria is in courtroom. I did see some correspondence filed by his attorney, Mr. Kevin Lennon. I don't know if the court wanted to.
I did get some,
June 18th.
I did understand with this, and I appreciate you pointing out, because I knew it was somebody, but I was being told on the phone, and I couldn't write the name down.
Yes, Your Honor. So I think it'd be easier at this point for me to ask the court to let us withdraw. He's already hired Mr. Catalanic as an attorney.
Right.
But it's also my understanding that there was going to be a request for continuance, and I'll let the court.
That's correct, and the court's fine with that. Mr. Cadillac contacted my office. He's at a deposition today. We would normally take a plea today. I think he entered a written denial.
We previously have entered denial on
Okay,
Mr. Gray's case.
so you've got a denial, and what we'll do is we'll just continue this to the next month, June 18th at 9 a.m.
Thank you,
Okay?
Your Honor.
Thank you. Do you have any others out of custodies?
No, I've got to see.
Mr. Farkas, you want to take a
Your Honor,
run
I
at it?
have one out of custody client, but
Okay.
I'm currently trying to work out an
Okay.
agreement with the state, so if we could pass him, it's Mr. Klein's.
Okay.
He's right here. I have another client who is out of custody, but he's not present.
Okay, we're going to give everybody a pass here for till later in the morning at least.
Okay, thank you.
For sure.
So other than that, all my clients are incarcerated.
Okay.
All right. I'll speak with this gentleman who just walked in, Your
Okay.
Honor.
Do you have any other out of custodies?
No, Your Honor.
I'm Mr. Medina.
Oh, sorry.
Good. Your Honor, I'm stepping outside with Jamari Bush.
Okay.
We have a plea agreement worked out, so I'm going to go over that with him, make sure we're all on.
Okay.
Thank you. Other than that, I don't have anyone in present.
Okay. Is anybody here that thinks they have a hearing this morning in the gallery? Okay. Mr. Harper's here. He's meeting with clients. Yes, sir? Who's your attorney? Do not have an attorney?
Yes, sir. He was the one I asked to pass because of the traffic. You
Oh,
called him.
okay. Come on up, Mr. Fletcher. Hold on. Okay, there you go. Okay. Mr. Fleshman, you're here today on several violations of probation. These are new charges. With these new charges, you do have the right to have an attorney. If you cannot afford one, one will be appointed. What I normally do in these situations is, one, give you a chance to have an attorney appointed if you want one. Enter a denial here today, which will preserve your rights, give you a chance to meet with your attorney. We'll come back in a month. You can look at your options and figure out where you're going.
I thought it was just one violation.
What's the state?
Your Honor, this is Mr. Fleshman.
Yes, it is.
Yes, the state's offer,
Okay, the state is making an offer, but just while you're thinking about this, you don't have to take it today. It's not a take it or leave it today. If you want to talk with your attorney, but depending on what the offer is, you might want to just deal with it today.
Yes, sir.
the state's offer is to admit the VOPs, reinstate, modify curfew from 11 p.m. to 7 a.m. for work purposes, complete all original terms of probation, and a $100 cost of prosecution, and that offer will remain open if Mr. Fleshman would like to consider it.
So what's the change? What is the addition?
The violation was for basically just violation of the curfew. So the state's offer is just to reinstate and to modify the curfew because all other conditions seem to be satisfied.
Okay, and so modify the curfew?
Correct, Your Honor.
How are you modifying the curfew?
From 11 p.m. to 7 a.m. It was earlier prior.
Okay, so you're actually giving him a little more time.
Correct.
Well, gosh, that's pretty good for a violation. You get a better deal.
Yes, sir.
You want to accept that?
Yes, sir.
Okay. You want to write that up?
I have the plea agreement, Your Honor.
That'd be great. If you show it to him and just,
Yes.
should just kind of walk through the key terms.
So admit the VOPs, reinstate, modify curfew, complete all of its terms, on trial, cost of prosecution. Since there's 3 cases, it's going to be per case, so it's not to 300. I will adjust that on the plea agreement. If you'd like to review this quickly, and this is your score sheet. The current score is 49. It reflects the opening cases that you have here and the prior cases that you have. Okay? So if you'd like to review this.
We'll have you can come up in just a second, Mr. Harper, as soon as we get through this one. You can do something.
I just saw. Your Honor, I'm just signing the plea agreement, and I will. May I approach? And the score sheet here.
Okay. Okay, Mr. Fleshman, I need to swear you in and ask you a couple of questions. You raise your right hand. Do you swear or affirm the information you're about to provide the court is the truth and nothing but the truth, so help you God?
I do.
So you had an estate attorney, obviously not your lawyer, but she walked you through and showed you the plea agreement that I see you've signed. Just want to make sure you're comfortable, you understand kind of what's going on. You're being reinstated with your probation, and it's actually modifying the curfew in a way that's a little more favorable to you. And of course, they always hit you with additional costs and fees.
Yes.
So you believe this is in your best interest to do this? There'll be a final resolution today, you understand that?
Yes, sir.
Okay. Court will accept your plea, reinstate, as it's stated on this, modify curfew to 11 p.m. to 7 a.m., complete all the original terms of the probation, standard fees and costs that are contained in here. Just stay in good contact with probation is the only suggestion.
Yes, sir.
You're good. Thank you.
Thank you.
Mr. Harper, you want to?
It is number 15 on the docket. She's before the court on 23 CF 818.
Hold on just a second. Go ahead, Mr. Hall.
Judge, she's before the court on a motion to modify one of the conditions of her bond, primarily, well, essentially the GPS requirement. She has been entirely compliant with pretrial supervision, has not caused any problems whatsoever, has not committed any new offenses, and the issue is that the GPS monitor is causing her issues with respect to employment opportunities, so she's becoming financially somewhat in a bad situation. So she's asking for a modification of her bond so that she can have the GPS monitor removed. Again, no allegations that she's been otherwise not in compliance.
State.
Your Honor, I am covering this for Mr. Losco. The state does oppose the removal of the GPS monitor, Your Honor. There has already been a motion to modify her bond, and Your Honor did reduce her bond in order that she wear a GPS monitor. The state is concerned about her whereabouts based on the underlying offense. She is alleged to have threatened to kill her former roommate, who is the victim. She does score prison based on her history. She has some violent charges, including assault on a law enforcement officer, battery on a law enforcement officer, battery, domestic violence, stalking, felony battery. So, Your Honor, the state is concerned about her whereabouts and does believe the GPS monitor is necessary.
And Your Honor, if I may.
Hold on just a second. Hold on. I'm a little confused on your motion. You say that GPS has made securing employment problematic, and then you say she works on Eglin Air Force Base.
No, the victim in this matter.
How the victim
The
does.
victim in this matter actually now resides
Resides out of state, I see what you're saying.
and actually works on Eglin. My client, is not able to interact with him out of state and is not able to interact with him on base.
I couldn't identify him if I saw him today.
So, and again, I would reiterate that she's had no problems with GPS while she's been out. I know that he's out of state because we had some difficulty trying to get him served for a deposition. That's how we found out that he was residing out of state.
If he resides out of state and works at Eglin Air Force Base, I'm confused.
I guess he just drives down, Judge.
When you say out of state, you just like
Out
up in
around
Florosa across the...
or something, yes, Judge.
Okay. So what is the difficulty in securing employment with the GPS?
With the summer weather, Judge, and she's trying to wear shorts, and it's quite noticeable that she has a GPS monitor. Even in pants, there's a bulge in her. Prospective employers have noted that, and she's not been able to secure employment.
I lost employment over it twice already. This was over a medical reason. I provided the medical documents.
Hold on just a second.
Never had anybody in my life.
Can the state verify that the defendant, not the defendant, the victim is out of state and works at Eglin?
Your Honor, I don't know his employment, but I can tell the court that we have a Dothan, Alabama address for him.
Well, let me ask the defense, does your client have any problem with staying, any reason she needs to be on Eglin Air Force Base?
No, I don't go 20 feet from my,
She will not go as an Air Force.
okay.
Okay, so the court will modify it, court will remove the GPS, but listen to me, ma'am. You need to listen to me. No contact is still in place.
Sir, I don't know
Okay,
him.
sir, ma'am, would you listen? Okay, this is what got you in the issue. Okay, listen to me. I'm trying to accommodate you to make sure you can get back to work. But no contact is very serious. It's 500 feet. It's incumbent on you to make sure. So if he walked up to you, or was she, I don't even know who the victim is, he or she.
I'm scared of him.
Walked up to you in public, you would be in violation of this. Okay, I'm just making clear you understand this. In addition, the court's going to have you cannot be anywhere on Eglin Air Force Base. Eglin Air Force Base is all over around here. You got to stay off Eglin Air Force
Okay,
Base.
so does that
You understand
like
that?
Creek, or I'm not sure.
I'm
where
sorry?
I'm not sure where are we talking reservation? Like, don't go to the creek even on Eglin Reservation Creek. Is that what it's summertime. I've got 12 grandkids. We were planning.
No,
So if
Eglin
it's
Air Force Base. Anywhere on Eglin Air Force Base, you'll be
So I can
removed.
pull off the side of the road and be on Eglin Air Force Base property?
Okay.
No.
Okay.
Yeah, that's right, ma'am.
Property.
Stay off Eglin Air Force Base. Okay? Just do that. If you're on a roadway driving through, and I'm talking about a roadway like 85 going through the reservation, that wouldn't be a violation. But if you enter off anything else, if you drive off of the reservation, you go back in there to, like you say, to go canoeing back in there. First of all, you got to get passes, which mean that you couldn't be on the base. And if you go through any base gate, I'm trying to accommodate you.
Yes,
I
sir,
know it's
I
a little bit
understand.
difficult.
No, sir.
We don't normally have this type of restriction, but I'm trying to make sure that your victim is protected at the same time as giving you the opportunity to work. Okay?
Nice. I
Anything
appreciate
you
this.
don't understand about that?
Yes, no, I'm just wanting to clarify to
Okay.
make sure.
Okay.
There was a trip planned with my grandchildren this
No.
weekend, and that
No.
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 I would never do it.
No. Until you get this thing resolved. Once you get it
Correct.
resolved, man.
It's been going on for
you
over a
can't-
year.
Yeah, well, unfortunately, these things do take
I
time.
understand.
Okay. Any questions? Okay, thank you.
Thank you, Judge.
Mr. Harper, do you have any other cases that you want out of custodies or anything?
Your Honor, I have one out of custody. I don't know
I'll get yours
if counsel-
next.
Counsel have any?
Mr. Nopes, you want to do yours?
Yeah, real quick, Judge.
Sure.
Judge, I got Gabrielle Johnson.
Okay, hold on just a second. Let me get that one.
Mr. Notes.
Okay.
But I know
Judge, we're here in 24 CF 227. My motion to reinstate bond, I've just spoke to the state. They have no objection to my request. Judge, I know that she's been incarcerated now for just a bit. Financially, I don't know if she could make a monetary bond. I'm trying to remember what her bond was on the previous case.
Madam Clerk, do you have the original bond on this case? It was an RR.
So Judge, we'd simply ask the court to reinstate that.
State?
The state has no objection, Your Honor.
Okay, without objection, the court will reinstate the bond, ROR bond. Just make sure you stay in touch with your attorney so you get this case resolved, okay?
It will be later today, they'll let you know.
Thank you.
Okay. Ms. Dudley, you want to
Yes, sir.
do some of yours?
What I'm getting, Your Honor, I'm covering for David Rare and Sean LaPella.
Who you?
David Rare on Mary with Gibson.
Hold on a second, huh?
Yes, sir. Is she on this morning's docket?
I don't have.
Maybe she's on, they thought she was on this morning, but she's supposed to be in the afternoon, so maybe she's on the afternoon.
Is
It's
it
15
on the
CF
arraignment, maybe? On the arraignment?
No, like 2:30 for a motion for early plea.
All I've got is 2 sentencings this afternoon.
So
What was that last name?
Do you have a case number and we can,
Yes, sir.
you can look it up?
15 CF 19.
15
CF
CF
19.
19?
Your Honor, Mr. Lasco did inform Ms. Jardina and I that there was an issue with that case, and I think they were, and I think he was asking that the case be pushed to 2:30. I guess there is a plea anticipated, but that's obviously at the court's discretion. I know we have other cases.
Which cases? I don't have his case at all on my docket.
If you'll give me just a second, Your Honor, I will get the.
So they say they thought a notice of a hearing, they thought it was gonna be, that they mistakenly put 9 o'clock instead of 2:30.
Your Honor, that's 15 CF 19 is the case number.
No, it's not on your docket because it was just filed yesterday morning.
But was it put on today's? Okay, and what type of hearing is it?
For a plea.
Oh, for a plea?
It's a plea to a violation, Your Honor.
Okay, so are you
They're
wanting to come
gonna
back
be-
this afternoon?
They're gonna be here at 2:30, Your Honor.
Okay,
If that's okay with the court.
okay, I'll allow it.
Yes, sir.
Hold on a second. 15 CF,
19.
and what's the name?
Mary Gibson.
Gibson? And is Mr. Rare going to be here?
Yes, sir.
Okay. Okay, very good. We'll deal with that this afternoon.
Yes, sir, thank you.
Sure.
I got Daniel Askew
Okay.
and 19 CF 3282. So I went over the plea with him, I just need him to sign it real quick.
Hold on just a second.
Yes, sir.
So this is a bond hearing, or did you?
We're gonna withdraw the motion for bond, we're going to plea, Your Honor.
Okay.
Can I come in approach?
You may. Thank you. Would you please announce the agreement?
Yes, sir. Mr. Askew will admit to the violation of probation, be adjudicated guilty, 9 months, Okaloosa County Jail with credit for all time served, revoke and terminate probation, $100 VOP fee, cost to judgment.
Very good. State?
Your Honor, that is the state's agreement, and just so the court's aware, the state will owe the court a score sheet. I will print it out and hand it to Your Honor. I believe Ms. Dudley has already seen it. This is a downward departure, but it's based on uncoerced plea bargaining.
Okay, very good. Mr. Askew, would you raise your right hand, sir? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Okay, so Mr. Askew, you heard your attorney state the terms of your plea agreement, and those terms are also in writing here. I see you signed it, so I just want to make sure you understand it. Have you read through this and gone over it in detail with your attorney?
Yes, sir.
And you understand that by entering into this plea, you're waiving the right to go to a hearing, force the state to prove their case?
Yes, sir.
You believe this is in your best interest to enter into this plea?
Yes, sir.
You're entering it freely and voluntarily?
Yes, sir.
Okay, based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt. You'll be sentenced to 9 months in the county jail. You will get credit for all time served. It's a $100 VOP fee. We're going to revoke and terminate probation. You're done with that. You don't have to worry. When you get out, you'll be straight, no more probation. all the costs will go to judgment.
Yes, sir.
Okay.
Thank you.
Do you want, rather than costs going to judgment immediately, to have 180 days to pay him? It might help his driver's
That's fine,
license.
Your Honor. 6 months to pay once he's released from jail.
Yeah, just,
Yes, sir.
so you'll have 6 months to pay the fees, and if you don't pay them, then it'll go to judgment.
Yes, sir.
Thank you. Okay, thank you, Mr. Askew.
The next one I have is Nareen Dykes on 26/29. That's. I can do more. Now, this is Jaron McCoy. And 19 CF 2428, 19 CF 2627, 19 CF 2628, 19 CF 2629, and 19 CF 2638. Your Honor, we are asking for continuance. I have reviewed this case, and what I can tell, seems to be some errors in the orders of probation and the disposition based on what he actually pled to, which will extremely affect his score sheet. The state and I are working on getting that resolved. And it also affects his Louisiana case that he pled to because they have him convicted felony, he wasn't convicted in this case. So that error here caused him to be convicted in Louisiana. So we're trying to work on that and get it right. He understands that we talked about it, so we're just asking for continuance.
Okay. How, just a 1 month, is that
Just 1
sufficient?
month, and then we'll come back and we'll see what we're on now.
So we'll continue until 6/18,
Yes, sir.
9 a.m. Dykes is out of custody, we have him out of custody.
He's definitely should be in jail, but I would, he's waiting to be taken to DSP.
What's that?
He's waiting to, this is the one where he was deciding if he was going to draw his plea or not. So he was in jail the other day, and he's waiting to go to DSC whenever we're done here.
Okay.
Correct. I'll check on it, Your Honor.
Okay, thank you. Is that your only cases?
Yes, sir.
Your Honor, I have an out of custody, may I see
You may.
Mr. Jamari Bush? Your Honor, I'm sorry, I don't know the docket number, but Jamari is spelled with Jhamari Bush, B-U-S-H. Mr. Bush is before the court in 19 CF 1059. We have a BOP agreement. It will be involving reinstatement and modification. There is no score sheet, and he would not be scoring to prison. The state has also agreed to resolve a criminal traffic case that's included in the agreement. That case is indicated on the agreement, but it's 23 CT 2887. May I approach with the agreement, Your Honor?
You may.
And I'm going to give probation a copy as well, Your Honor.
Thank you.
If I may, just give them a copy. Your Honor, under the terms of the agreement, defendant is admitting the violation of probation in 19 CF 1059. He's pleading no contest as charged in 23 CT 2887. In 19 CF 1059, he will maintain the withhold of adjudication, reinstate and modify supervision to convert the remainder to community control. My understanding is that his supervision extends into January of 2025, so he's going to have several months on community control. The rest of 2024 and a little bit into January of 2025. That's my understanding, based on what was in the report.
The 25th of January.
I understand, but that's just, I'm just basing it what's on the report. Complete existing obligations, $100 cost of prosecution, 150 public defender fees, and 23 CT 2887, withhold adjudication, 6 months concurrent probation, show proof of valid driver's license or eligibility, $270 court costs, $50 public defender fees, and he does have his driver's license, so he should be able to comply with that driver's license requirement when he meets with probation later today. And that is the agreement, Your Honor.
Very good. State?
That's the state's agreement, Your Honor.
Okay. Mr. Bush, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
Just want to ask you a few questions, make sure you understand what you're doing and you're entering it freely and voluntarily. Pretty straightforward. You heard your attorney state the terms of your plea agreement, and I see those same terms are written down and you've signed it, right?
Yes, sir.
Have you read through this?
Yes, sir.
And gone over it in detail with your attorney?
Yes, sir.
You understand that by entering this plea agreement, you're waiving the right. It's a pretty straightforward agreement. It's not complicated, but you're waiving the right to go to a trial. This will be a final adjudication of both your violation of probation as well as your traffic case. Do you understand that?
Yes, sir.
Okay. You believe this is in your best interest to do this? Mm-hmm. Have you had all your legal questions answered by your attorney?
Yes, sir. You're pretty good.
Okay.
You're pretty
Very
nice.
good. Okay. Based upon that, the court will accept your plea agreement, and as to the VOP case, 19 CF 1059, the court will maintain the withhold of adjudication. That's important. Reinstate and modify supervision to convert the remainder to community control. So from here on out, not changing the term of your probation, but it's going to community control, which that's kind of like that's not kind, that's house arrest.
Okay.
More supervision. You understand what that means? Because I don't want you to, hey, I didn't realize I had to do all this extra stuff, and then you get violated, you come back, and they try and bust you. Do you understand what this community control means?
Yes, sir. He explained it to me.
Okay, very good.
And
So you
think, Your Honor, I think he originally did do some community control,
Okay.
if I'm not mistaken.
It's just important that people need to understand going in, there's a lot more supervision. I mean, you basically can't go anywhere. It's not like probation where you've got a curfew.
Right.
This is like, no, you can't go out at all.
Right.
Unless you're going to a job or something you clear in advance. It's different. It's more higher level of supervision. It's basically a little harder to comply with. But I want to make sure you understand that, so you don't want you to be successful. That's the bottom line.
Me too.
You got to start with understanding what you're getting into.
Yes, sir.
Okay? So you've got the standard fees and costs, et cetera. On the traffic case, it's also withhold of adjudication, 6 months concurrent probation, so it'll be probation be running at the same time as the other one. And then you got to show proof of valid driver's license, and there's fees and costs. But you apparently already have that, so you can you'll have met that, but you need to show the probation your driving license. Okay?
Okay, sound good.
Any questions?
No, sir.
Okay. Thank you very much.
Thank you. Y'all have a good day.
Okay.
Take care. You can take this just for a copy when you meet with probation, okay? Thank you. Thank you.
Judge, I do have one more. I see Lady Green, number 14 on the docket. Judge, before the court on 23 CF 1997. Judge, we're going to ask to move this to the June pretrial. The issue is that she's been offered diversion, but I think one of the terms is not really clarified, and we'll probably get that resolved next cycle, Judge, but we just need to get clarification on that term.
Okay, so we'll continue that until 6/18 at 9 a.m.
Is it 6:10 or?
Well, oh, you want to do the pre-trial?
Yes.
Okay, I'm sorry, I thought you wanted next month's miscellaneous. The pre-trial will be June 10th.
Thank you, Judge.
6/10.
June 10th, 9 o'clock.
Ms. Dudley?
Yeah, I believe address Mr. Hyde's case.
Okay.
He is incarcerated. Is there any way we can, he thought he was going to be in court today. Is there any way we can bring him this afternoon? But he is in the county jail. I've checked the website. He's still there. He was there when I talked to him the other day.
Okay.
It's 22 CF 29.
Hold on
Yes,
just a
sir.
second. Okay. Yeah, we can bring it back this
Yeah, I just
afternoon.
don't want to do anything without him being present, even though we're going to
Can
continue.
we bring this afternoon, like, on this afternoon's docket?
Yes, sir, I'm going to take a look now.
Okay, so
What time you're on? 1:30?
we'll start, why don't we bring it back for the 2:30?
Yes, sir.
So we've got the arraignments
Yes,
at
sir.
1:30, and then we'll start up at 2:30.
Yes, sir,
and we'll
I'll
do-
be here. Thank you.
Sure, thank you. Okay, Mr. Harper, do you have any others?
They're all in custody, Judge.
Okay. Okay. You want to start with in custody?
Sure, Judge.
Okay. Mr. Flowers, do you have anything? No.
The matter that I had,
Hollingsworth, correct?
Judge, while you were taking other cases, I stepped out my office, contacted Mr. Hollingsworth, who was under the impression, well, we'll put it this way, he wasn't here, he knew to be here, and he's on his way here.
Okay.
But Judge, he knew to be here, and we'll tell you that
Okay.
mea
So
culpa. But he's on his way here, expects to be here by 11 a.m.
That's fine.
My office tells me so.
Just wave at me when he comes in,
Yes, sir.
and we'll get him up.
Very well.
Mr.
Ms.
Harper?
Basso will be pleased to wait. Awesome.
I know she will. Shouldn't have anything else to do today. You want to do? Okay, go ahead.
I apologize.
Sure, no, that's all right, no.
Your Honor, the first one is Anthony Klein's, excuse me, 2022 CF 1942. He's approaching right now. This is a VOP. I've been back and forth with the state attorney. This was meant to be the last continuance, but Ms. Sharpless has agreed to one last continuance, if Your Honor would allow, so that I can continue speaking with my client about the offer.
Okay.
We did get an updated offer today, and Ms.
Okay,
Sharpless said it would remain open.
We'll continue this till 6:18 at 9 a.m.
Thank you, Your Honor. The other out-of-custody client I have is Zachary Dispinette. He is approaching 2022 CF 745. Similarly, Ms. Sharpless has agreed to one last continuance, if we could also have the 6/18 date for Mr. Dispinette.
Okay, we'll come back on 6:18 at 9 a.m.
Thank you, Your Honor. Those are all my out-of-custody clients.
Okay, Mr. Harper?
Yes, Judge, I have 3 in custody.
Okay.
This is Mr. Arnold, number 12 on the docket. He's here before the court on a bond hearing.
Okay, hold on just a second. Okay, go ahead, Mr. Harper.
Judge, Mr. Arnold's before the court on 23 CF 1068. We're here before the courts on a motion to reduce bond. Without regurgitating the entirety of my motion, Judge, basically, one of the conditions of his bond was GPS monitoring. He had a signature bond. There were some issues with his GPS monitor, and then he had to get that replaced, and then subsequently, there was a court order revoking his bond in November of 2023. Notwithstanding that, he still maintained contact with pretrial supervision.
Okay, I'm a little bit confused. So are you saying that his bond was revoked because there were mechanical issues with the GPS?
In my paragraph 2, Judge, initially there were some mechanical issues. His GPS monitor was actually replaced, and that's in the pretrial services report.
And are you saying that's what caused the revocation of the bond?
No, Your Honor.
Okay, that's what I thought.
That's not entirely my understanding. I think the pretrial services report indicates that there was some, it appears as though it was not charging or was not charged. And I only noted the fact that there had been a recent replacement because of the fact that it happened. What I am asking for is that, notwithstanding that, he still maintained contact with pretrial supervision, even though the order was issued by the court in November of last year. He still maintained contact with pretrial supervision by phone, and he still maintained the GPS monitor on his person. He didn't cut it off or anything like that. He was picked up by law enforcement pursuant to that order issued in November. He was picked up in April of this year. So what I'm asking for is that the court to take note of the fact, apologize, to take note of the fact that notwithstanding the fact that there was a pickup order and that there was some, his GPS monitor wasn't charging fully, that's the allegation, and therefore they were saying that they weren't able to track him. He still had the GPS monitor. He still maintained contact with pretrial supervision by phone, and he is asking for a reduction of bond so that he can hopefully pursue a defense on the outside. There's a motion to dismiss that's pending in his case, and we're hoping to get to a resolution sooner rather than later.
So what is the current bond?
His bond is revoked, Judge. They were signature bonds with GPS.
So it's not a motion to reduce the bond?
It would be a
motion
motion
to reinstate the bond?
Yes.
Okay. Reinstate. State?
Your Honor, the state does oppose the motion to reinstate this bond. Pretrial services stated that after the court giving him a bond in July of 2023, which included that he should wear the GPS monitor, he was given a new monitor on October the 18th.
October 18th, what year?
2023.
2023?
Yes, Your Honor. And then the pretrial services report that had his bond revoked states that on October 25th, 2023, the defendant received battery alerts and alerts that he was unable to be contacted. And that they state that that indicates that the GPS unit has stopped tracking. And they did make note again that he did receive new equipment on October the 18th, indicating that his equipment should be working. When I spoke with pretrial services, they did indicate that he would make phone contact with them, but would never report in person, despite being warned several times to report in person. Your Honor, I know it has been 6 months since the court issued an order to take him into custody. Pretrial services is not suggesting that he did not call in, but he would not meet with them in person. And I suspect that that's because he knew there was an order to take him into custody and did not want to be taken into custody. So he was evading being taken into custody, Your Honor.
So I'm still confused over that the original violation was caused on a technical issue. I'm still confused over that.
Your Honor, if I may, I don't think that I can say with definitiveness that that's the cause of the alert, Judge. What I will note, and that's in paragraph 2 of my motion, is that
because it says the GPS unit was not tracking. I don't know what that means. What does that mean? I don't know what that means technically.
And the allegation, I think, associated with that in the pretrial supervision report was that it was not charged, and therefore could not track. And the only
it wasn't charged, so he didn't charge it properly, and therefore it stopped tracking.
That's what they're asserting, Judge.
Okay.
And I only note that is that before the replacement of his unit, the week prior, on October 18th, there had been no issues with him on GPS monitoring. It was until the replacement, which happened on October 18th, and then the non-tracking issues that pretrial supervision filed on October 27th, basically a week later, that resulted in the issuance of the order revoking the bond. Obviously, I don't know what caused the malfunction, but up until this point, there have been no issues. And notwithstanding that, again, he still maintained phone contact with pretrial supervision, although he did not show up in person, as Ms. Sharpless stated. But despite that, he's still.
When did he get picked up?
He got picked up in April of this year, Judge.
April what?
April the 18th.
18. So what's the state seeking as far as a resolution of this matter? Where are you guys going to a trial? Where are we at with this violation?
There's a motion to dismiss pending, Judge. I think we're just waiting
Motion
on.
to dismiss on the bond?
On
the VOP?
On the substantive charge itself, Judge.
Of the VOP or the underlying?
It's just an underlying.
It's a new case, Your Honor, it's not a violation.
Okay, so with the bond?
It's a constructive possession argument, Judge, essentially. There are multiple occupants of the vehicle.
Or do we have that set?
It's been filed. I don't know if it's set yet, Judge. But I can inquire about that and get it set if it's not.
Court will reinstate the bond, but it'll maintain the GPS tracking. And if you violate the tracking again, you won't be getting out until you get your case resolved.
Yes, sir.
Thank you.
And for tracking purposes, I think this is currently set for 6/12.
Okay, so let's change it to 6/10. And you can go ahead and set the other one in the afternoon.
This is actually Antonio Clark, number 13 on the docket, Judge, 23 CF 2050 and 23 CF 2098.
Hold on just a second. Okay.
The court may recall that we had set this for status. He had entered a plea to 23 CF 2050 last trial cycle, and we did a little bit something odd. The court may recall is that we entered a plea, but we deferred sentencing. We deferred it until, frankly, last week because there was the anticipation that we would come to a resolution on 23 CF 2098 in that the victim in this matter had both recanted and stated that she fabricated the allegations with respect to counts 1 through 3 in that case. And then we would just be entering the plea to drug and suspended. We then continued from last week to this week in the hopes of getting clarification and coming to a resolution today. It's my understanding that the state's not ready to proceed forward on that. Mr. Clark is quite frustrated and upset with that delay. And he's, I believe at this point, he might be wanting a Nelson hearing. I'm not certain, but...
I don't understand what I signed for. They told me if I sign anything, it'll be time served.
Like, why am I still coming back and forth to court?
So I don't know if
They
we
told me
need
time served.
to set this for possibly a miscellaneous court date to proceed forward on the Nelson hearing. I think he might be wanting to withdraw his plea as well, and that we had sort of prefaced this to sort of come to this resolution, and we're not able to do it at this time. So if we can set this for June the 13th and carry all of his cases over to June the 13th, I believe that he would like a hearing to resolve this case.
I want to know, like, why Taylor Sharp just said we was going to have it resolved today. Why do we have to keep coming back and forth to court? Like, I'm obviously innocent. I didn't do anything. So why am I still coming to court? I pleaded out to what you told me to plead out to, and you said this would be resolved. Now we still coming back and forth to court.
And
like,
for clarification, Judge, it was
this was what I was told. That's why we went back and forth 3 times that last court date. Like, why no depositions? Like, what's going on in this court date? What's going on?
I mean, you're asking questions. I mean, I don't. Obviously, what's going on is that you're in the middle of a negotiation between the state and yourself. And just so you understand, because there's a couple cases making it a little tricky. When you have a negotiation, a lot of people don't understand this. The negotiation is between 2 parties. You, with your attorney, you and the state. It's like any other kind of negotiation. First of all, I got nothing to do with it. I don't know anything about it until you actually have an agreement. You come to the court and say, will you accept it? If it's fair, both sides agree, 99 times out of 100, I accept the plea, right? I don't have it, so you're asking me, I don't know. But there's a negotiation going on between you and the other side, and until both parties agree, it don't matter what you can be the most reasonable guy in the world. And if the state don't agree, there ain't an agreement, because there's got to be 2 to have an agreement. I understand what you're saying. Hey, they said this, they said that. I don't know all the details. I don't know why it hasn't been resolved. But
I just want to know what did I sign for? Why did they need my signature? If I wasn't going to be sentenced on the original charge, the first charge. Why did I have to sign?
I don't think we can come to a quick resolution as to that answer. There is an answer, but I think that might be best suited for a separate hearing, Judge, on June 30th.
I agree. So you want to come back on the 13th? And if you want a new attorney, if you don't want your attorney, you got to file a Nelson hearing, file some paper with the court. We'll hear it on the 13th and get it done.
Are we set for trial? Is this set for trial, or what's going on?
What I would like to do, Judge, in that 6/12 would be his normal court date. If we could have a hearing on that date and then either proceed, I would be electing to proceed forward to trial if we're not come to a resolution on that date. Because I agree with him with respect to the newest charge that I don't think the state can meet their burden of proving this case beyond a reasonable doubt with respect to counts 1 through 3. So I would be asking for.
Okay, so let's come back on our regular court date for pre-trial on 6/12.
Even 1 through 4. Because without that, there wouldn't be no other charge.
If we can't come to some agreement, then we'll go to a trial.
So, Your Honor, just so we'll set it for, we're setting it for the regular inmate pre-trial. And then if he files the Nelson hearing, we can hear that on June 13th if it's noticed for that day. And Your Honor, what's going on here is that the stuff that's being brought up requires legal research. When I go back and read the victim's statement, victim input form, and watch the body camera, there's legal research to be done, things that get brought up to me. Hopefully on 6/12 that'll be resolved and we can either go to trial or the counts that the victim is a necessary witness will be dismissed, Your Honor. That's what the state is working on. The state's not working on this case. There's stuff to be.
If you're not hearing that, I'm going to give you an answer to your question. What's going on? The state ain't agreed. That's what's going on. And they're still looking at it. It's not your attorney, the state. You presented something, you believe you got a case, your attorney is arguing that with them, and they're saying, I got to look at it. I got to do some research. When the attorney said I got to do some research, that means there's something serious they're looking at. Anyway, that's an answer to your question. Come back on 6/12.
It's been 9 months. Like, how much more research do they need? Like,
Okay, well, I understand. I'd be frustrated too if I was still in jail.
man, what about my bond? Can I get my bond reinstated? It's
We're not
driving
here on
me
that
home,
today.
y'all.
Which case?
Judge, this is William Adams, number 11 on the docket. Judge, we have set this for status to come to a possible resolution this cycle. However, at this time, the state and I are not able to come to terms. If we can just set this for 6/12, we'll come to a resolution that cycle.
Very good. We'll come back on 6/12.
Yes, sir, Your Honor. Thank you.
Thank you, Judge. I believe that's all I have this morning.
Those are all your in and out? Okay.
Yes, sir.
Ms. Farkas, you got that?
We can start, I think my first in custody client is Joshua Cruz. I can start with whoever you have.
That's Tatum.
Oh, that's fine.
Still yours?
Yeah.
22 through 26, and alternatively, 22 through 26. Yes, so that's
Your Honor, I think we're starting with Tony Tatum. There's two dockets, 2020 CF 1825 and 2020 CF 2406. Oh, okay. That's okay. I'm flexible.
Working on the meeting inspector.
Only Elizabeth Dills.
Yeah, Carter Bill.
Who is this?
This is LaQuetta Carter,
Okay.
2023 CF 1265. Your Honor, I believe this is the first time this BOP is up. Ms. Carter will enter a denial, and we'd like a continuance so I can speak with her at the jail.
Very good. We'll continue this until 6:13 at 9 a.m. What do we have? 13, 18, this jail. And that's, is that counting the ones we had today? We added 6 or 8 today. It's about 20 and 50.
Good day, Judge. Your Honor, this is Elizabeth Dills, 2023 CF 2313. I'm having her sign the plea agreement that we have gone over already.
Okay.
Thank you, Judge.
Thank you, State.
It's the 21st. And if I may approach, Your Honor.
You may.
Your Honor, like I said, this is Elizabeth Dills. Before you, you have the CF docket. She has an open misdemeanor docket that will be included in this plea that the state has agreed to. So in docket 2023 CF 2313, Ms. Dills will admit the VOP and maintain the withhold of adjudication that was previously entered. We will reinstate probation and modify to include a special term of probation, which is 5 months Okaloosa County Jail, credit for all time served. Supervision will be revoked and terminated upon release from OCJ. $150 public defender fee, and I should note there that she will have time to pay, so I can edit that plea agreement. In 2024, MM 1466, which is a misdemeanor trespassing, that will be an adjudication of guilt, credit for time served, $270 in court costs, and no trespassing at 609 Gap Creek Drive, Fort Walton Beach, Florida.
Okay. Ms. Dills, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
State?
That's the state's agreement, Your Honor.
Okay. So, Ms. Dills, you heard your attorney state the terms of your plea agreement, and those terms are in the written plea agreement that you've signed.
Yes, sir.
So, you just want to make sure, have you gone over this with your attorney in detail?
I have.
Make sure you read through this. You understand you're waiving some valuable legal rights, right, to go to a trial, contest this. You believe this is in your best interest to enter into this plea agreement?
Certainly.
Okay. And you have had all your legal questions answered?
Yes, sir.
Okay. Based upon that, the court will accept your plea. And on 23 CF 2313, the court will maintain the withhold of adjudication. This is an admission of the VOP. Court will reinstate probation and modify to include a special term of probation of 5 months in the Okaloosa County Jail. You will get credit for all time served. Supervision will be revoked and terminated upon your release from the county jail. Then you've got the attorney, the fees and costs that'll, you'll have 180 days to pay those, and then before it goes to collections. On the misdemeanor, which is 24 MM 1466, there'll be an adjudication of guilt, and your sentence is essentially credit for time served. So, in there, of course, and in addition, there's no trespassing.
Correct.
Who's the estate?
This is my case, Your Honor.
It says no trespassing, but the misdemeanor, there will be no probation with which to enforce a no trespassing. How do you have a no trespassing? Is that like forever?
Your Honor, it was my,
It's
if you'll give me just a second, Your Honor, it was my understanding that there was already a trespass warning issued for that. So it would be for at least the year for the trespass warning, Your Honor, that would be enforced. It would be another trespassing charge for her to return because she's been given.
But that's not a part of this charge, is it? Is the no trespassing a part of this plea agreement? Ms. Farkas?
I won't go there. I won't.
I understand it, man. It's a technical issue.
Gotcha.
That's for the 180 days.
It's part of the 24 MM 1466, Your Honor. Would
I understand it, but it's credit for time served. It's done. How can you have a no trespass when the case is done? How long is the no trespass?
Your Honor,
If it's for a no trespass based on a warning, is
Your
that
Honor, my understanding,
part of the plea?
my understanding, at least in the misdemeanor court, because this happens all the time, is that the trespass lasts for a year. Do you remember? I think it's a year, and it doesn't require probation to maintain it. Just as like Walmart can trespass someone from the property for a year, and it doesn't require
Well, I understand
supervision.
that, but that's a separate process.
Yes, Your Honor.
This is a no trespass that's a part of a plea agreement for another case. Just trying to make sure technically, we don't normally, usually the no trespass is when you have a period of probation, not credit for time served. And
I apologize.
now-
My understanding was that the no trespass order could exist absent supervision
Yeah.
to enforce.
So it
That's
can
my
last for a
understanding.
year.
Yes, Your Honor.
yes.
And we can
Would
always
that
modify
have to
the
be put
plea.
on there that it's no trespass for a year?
I can add it.
I don't know, I'm just, we don't normally have these this is a little bit unique. Maybe it's not unique in
I think it's not so much
county
unique,
court,
right?
but it is. in
I
this
can
court.
add it, like, I can just add for 1 year, just to
That's
clarify.
Just a,
Because the main thing we want to do is make sure when we enter a plea make sure the defendant understands what she's pleading to.
Yes, Your Honor.
So if it was for 2 years, she needs to know, can't trespass for 2 years. If it's 1 year, it's 1 year.
If I may correct.
Okay, very good. Okay, with that little discussion, you're on the misdemeanor charge, you get credit for time served, that's the charge. But a part of that is a 1 year no trespassing at Gap Creek Drive, 609. So
Understood.
I know as a practical matter, you're going to stay away from that.
I will.
And won't have anything to do with it. Do you have any questions?
No, sir.
Okay, thank you very much.
Thank you. Give my best to Judge Schleifer, please. Thank you.
Thanks, Steve. Tatum.
Okay.
Tatum?
Your Honor, this is Tony Tatum. There are 2 dockets in front of you, 2020 CF 1826 and 2020 CF 2406.
There's less than a criminal traffic case.
Yes, there is. There is a case in the criminal traffic court that is the
Right.
instigator of the VOPs. VSOP in front of you.
Hold on a second. Go ahead. Oh, well, I'll find it. Go ahead.
Thank you. Okay, so this is Mr. Tatum. I've spoken with Noah Losco, who I believe is Taylor Checklist today, about this case, and I'd like to request a continuance as we're in negotiations about the offer. There was a slight change to it yesterday, so I want to be able to speak with my client about it.
Okay, so we'll continue this matter until 6/18, both cases, actually all 3
Thank you, Your
cases.
Honor. Thank you, Your Honor.
Thank you.
Your Honor, this is Joshua Cruz, 2023 CF 1541.
Okay.
Your Honor, I've been speaking with the state about this case as well. There is an offer for a treatment program. Unfortunately, my client wasn't accepted to Keaton, so we're trying to find another program. If we could have a continuance,
Okay.
that would be much appreciated.
We'll continue this till 6/18.
Thank you, Your Honor.
Okay.
Next, Curley.
Your Honor, this is Gus Curley. 3 VOPs before you, 2022 CF 1028, 2022 CF 1532, and 2022 CF 1542. He did have a VOP date in February. He did not appear, so just to be sure, he's going to enter a denial in the VOPs if it hasn't already been entered. And we request a continuance in all 3 cases, please.
Has the denial been entered? I think it has.
I think it has, but I didn't want to risk it.
Okay.
Okay, thank you.
So the court will deny and we'll come back on 6/18 at 9 a.m.
Thank you, Your Honor.
Thank you.
Thank you.
I'll see you.
Figures?
Appreciate everything, Your Honor.
Your Honor, this is Leroy Figures, 2023 CF 1120 and 2023 CF 1390. Mr. Figures has a new law case that is set to be arraigned on 6/13. So given the change in situation, we'd like a continuance because obviously the new case is going to affect the outcome of the VOPs.
So do you want to come back on 6/13?
If we could.
6/13 and 6/18, do we, you want to do it?
Let's just do 613 so they can track together. That would be
Okay.
perfect.
Very good.
Thank you so much, Your Honor.
Thank you. Good luck.
Stay safe here.
Yes, ma'am.
Thank you.
Fullerson?
Yep.
Your Honor, this is Donald Ferguson, 2023 CF 445. This is the first time the VOP is up, I believe. If we could enter a denial, he does have a new case. I think that's also set to be arraigned on 6/13. Is that correct? I just want to make sure that that's the date, because if so, then I'd like to continue this one to the same date.
Do you have a case number for the new case?
Yes, 2024 CF 1069. Okay.
Okay, so we'll continue this one till 6/13 as well.
Thank you, Your Honor, and a denial in this one.
And enter a denial
Thank
on
you.
behalf of the defendant.
Thanks. Okay, I'll see you today.
Ms. Farkas, is that all yours? I think it is. Yeah, well,
I have Michael Daly, who's on the afternoon docket, but I'm happy to call him, because then that would be everybody. Well, I have one more who's in out of custody and is not here. So I just have Michael Daly and then William Egbers, Egbers. We can do that one now as well.
is that on this morning's docket?
I believe so. 2024 CF 871.
Is that in custody? that-
No, out of custody.
Okay, hold on.
It's an arraignment. Oh, then he might be on the afternoon. I'm sorry.
Yes.
My
Okay,
apologies.
do you have any more this morning?
No, I do not.
Okay. Why don't we go ahead and take a short break? Unless, you need to deal with one?
No, Judge, I was late because I had a deposition.
Okay, that's all right. A lot of people are late here today with all this traffic. Is the traffic cleared out there finally?
Yes.
Okay.